incorporated into ADR programs by corporations, which seek, through clear vision and planning, to keep an eye on the bottom line. ADR cuts across a wide range of industries, and in industries with a large number of claims, many concerned professionals have developed their own dispute resolution forums. For example, the self-regulating organizations, SROs, of the securities industry, the New York Stock Exchange, the American Stock Exchange, regional exchanges, and the National Association of Security Dealers, NASD, hear and resolve customer broker disputes through their own private forums. Other industries which have a long history with dispute resolution include the construction industry, which has spurred the development of techniques to resolve conflicts before positions are allowed to harden through partnering and dispute review boards, and the insurance industry, which resolves hundreds of thousands of disputes annually through ADR for matters involving product and professional liability, reinsurance, no-fault, and uninsured motorist claims. For many years, the labor management community has included provisions in their contracts for grievances to be resolved through arbitration. In the non-union setting, conflicts arising out of breach of contract, wrongful termination, sexual harassment, and discrimination have redefined responsible corporate practice and employee relations. Many corporations have developed flexible, tailored ADR provisions for personnel manuals, contracts, and employee handbooks. Crucial to these programs are procedures which ensure a fair and equitable dispute resolution process for both employers and employees. ADR and the U.S. federal courts is another topic. As court caseloads continue to rise, compounded by the dramatic increase in criminal case filings and the complexity of those cases, many believe that the federal courts in the United States are approaching crisis. Some believe that if the court's civil and criminal jurisdictions continue to grow at the same rates as over the past 53 years, the picture 25 years from now will only be describable as nightmarish. According to the Committee on Long-Range Planning of the Judicial Conference of the United States, the number of civil cases commenced annually in 2020 could reach nearly 1 million cases. In 1995, the number of civil case filings in the district courts numbered about 180,000. The courts have increasingly encouraged parties and their attorneys to attempt to resolve disputes through mediation or arbitration. In fact, since 1978, the U.S. federal courts have been experimenting with both mandatory and voluntary, non-binding, court-annexed arbitration. However, although the use of ADR under the aegis of the courts has rapidly increased during the past few years, the question of the government's willingness to continue to fund these systems has moved to the fore. The American Arbitration Association's experience with bankruptcy mediations in Florida, Ohio, New York, and Michigan, as well as with mass tort and complicated commercial cases, leads us to believe that in the future a significant number of large multi-party cases across are appropriate for mediation or arbitration. The association and other ADR providers should be viewed as a resource for the courts, capable of being process expediters at different points in complex litigation. The leader in conflict management since 1926, the American Arbitration Association is a not-for-profit public service organization dedicated to the resolution of disputes through mediation, arbitration, elections, and other dispute resolution procedures. In 1995, more than 62,000 cases, that number equals approximately 1/3 of the civil cases filed with the U.S. federal district courts, were filed with the association in a full range of matters including commercial finance, employment, environmental, healthcare, insurance, international, real estate, and securities. In addition to ADR services, the association offers hundreds of education and training programs each year throughout the world. Well, who are the neutrals? The caliber of the neutral has never been more pivotal to the quality of dispute resolution. Although there is no formal accreditation program for arbitrators and mediators, today's neutral must be equipped with greater knowledge and skills than ever before. Many neutrals are retired judges, attorneys, and business professionals with discrete industry expertise recognized for their standing in the business or legal community and respected for their integrity and dispute resolution skills. Competent neutrals must also be trained in the art of mediation or arbitration and in the ability to manage the flow of documents and the hearing in fidelity to providing a prompt, efficient, and less costly means of dispute resolution. Finally, industry knowledge and standing of a neutral, while important, aren't enough by themselves. Good arbitration and mediations arise out of a well-administered process which values integrity and through democratically developed rules and procedures which contemplates the involvement of highly trained administrative staff and the presence of a credible, enduring institution. Now a word about the history of ADR. Before we explore the driving forces behind the use of ADR in the international arena, let us reflect on our past. Long before law was established or courts were organized or judges had formulated principles of law, mankind had resorted to arbitration for the resolving of a discord, the adjustment of differences, and the settlement of disputes. It has been noted that 25 centuries ago, arbitration was recognized by the Greeks as a means to quickly and efficiently settle arguments. In fact, according to legend, it was upon Mount Ida that the royal shepherd Paris was called upon to deliver a famous award. The dispute concerned the competing claims of Juno, Pallas Athene, and Venus for the prize of beauty. All means of settlement having failed, Paris, by agreement of the parties, decided the issue. I guess that's when the titles of first runner-up and Miss Congeniality were created. Through Paris' intervention, war amongst the gods was averted. Now, if the course of arbitration begun presumably on Mount Ida could be traced throughout history, it would be found in the most primitive society as well as in modern civilization. Commercial arbitration was known to the desert caravans in Marco Polo's time and was a common practice among Phoenician and Greek traders. But it was also known to the ancient world for the settlement of many political disputes. In a controversy between Athens and Megara about 600 BC for possession of the island of Salamis, the matter was referred to 5 Spartan judges who awarded the island to Athens. A dispute between Corinth and Corcyra for the possession of Leucas in 480 BC was settled by Themistocles as the arbitrator. Again, historically, in early industrial society, controversy was arbitrated for terms of employment, working conditions, and wages. One of the first known disputes submitted to the earliest known American arbitration tribunals, organized in 1786 by the Chamber of Commerce of New York, involved the wages of seamen. In industrial America after World War I, as public courts were flooded with cases, the business community became interested in private arbitration tribunals. In order to enhance arbitration's effectiveness, however, the common law governing arbitration needed to be changed. Modern legislation giving parties the freedom to enforce arbitration clauses became a prime objective for the business community in meeting its dispute resolution needs. Inspired by Julian Cohen's Commercial Arbitration and the Law, the New York Chamber of Commerce and the New York State Bar Association co-sponsored arbitration legislation. In 1920, New York became the first state to enact a modern arbitration statute which enforced arbitration clauses in signed contracts. This law put the power of the New York courts behind arbitration agreements and paved the way for the widespread enactment of similar legislation. In 1922, business leaders created a new organization called the American Arbitration Society of America. The society began with a strictly educational mission aimed at advancing the use of arbitration. It recognized that people would have to be educated about the benefits of arbitration. Its periodical, the Arbitration News, passed the word. Extensive lobbying was carried out. In 1925, Congress passed the Federal Arbitration Act, which enforced arbitration clauses in interstate contracts, thus providing a firm foundation for modern business arbitration as we know it today. The society gathered momentum and moved from being primarily an education institution to becoming a full-service dispute resolution organization. It recognized that not only was additional legislation needed, but contract clauses and procedural rules would have to be designed and arbitration panels established. In 1924, another arbitration organization was formed. The Arbitration Foundation, as it was called, took a more conservative approach than the society, devoting its efforts to research rather than action. The foundation depended on private grants, and at first it was criticized by the society for lacking, quote, democratic approach, close quote, and not reaching out to a broad base of potential users. A standoff between the society's practicing lawyers and businessmen and the foundation's major commercial interest. Leaders on both sides tried to reconcile the differences between the organizations. Negotiation continued for more than a year. In 1926, with the help of a mediator, a negotiated settlement was reached and resulted in the merger of the foundation and the society into a single organization called the American Arbitration Association. Let us now focus on the growing use of arbitration and mediation to resolve disputes in the international arena, international negotiation, and conflict. The growth of international trade, investment, and commercial transactions in the 20th century, and particularly over the last 40 years, has resulted in a clear system of private commercial dispute resolution across national borders. In the past, contracting parties engaged in international transaction were not comfortable thinking about dispute resolution as they drafted their contracts. They tended instead to think in terms of successful ventures rather than failed projects and accompanying disputes. Today, however, when multinational corporations are involved in cross-border business, they routinely express their desire to avoid the uncertainty and delay associated with litigation in foreign courts. As a result, corporate counsel and their attorneys, when entering into business relationships with foreign partners, have increasingly turned to alternative dispute resolution to resolve an international conflict of almost any significance. ADR is now applied in almost every aspect of modern business and is incorporated into day-to-day contracts. When Apple Computer Corporation and the Internal Revenue Service found themselves in a complex financial dispute, they turned to the American Arbitration Association to resolve it through binding arbitration. The chairperson of the three-member arbitration panel, a member of the AAA Large Complex Commercial Case Program, teamed up with an economist and an industry expert to resolve the multi-million-dollar dispute that involved the transfer price of printed circuit boards that Apple bought from its unit in Singapore. Apple claimed its costs were $131 million. The IRS, on the other hand, argued the fair value was only $16.3 million, which would make Apple's taxable income from resale in the United States far higher. Baseball-type arbitration required each party to offer a new alternative figure for each year at issue and to accept a choice of one or the other. The arbitration panel chose IRS numbers over Apple computers. Yet in the end, Apple's tax director, John Brennan, said the process moved the parties toward a settlement and saved more than 2 to 3 years in costly litigation. Because of successful resolutions such as the Apple computer IRS conflict, the use of arbitration and mediation, the two most common dispute resolution processes, has gained worldwide acceptance and application. Today, we have international arbitration rules and dispute resolution centers throughout the world. Indeed, as trade grows under such accords as NAFTA and GATT, ADR will increasingly become more global in its influence and reach. The coming era of international arbitration will be one of tremendous growth, accelerated by the ever-increasing awareness of alternative dispute resolution and augmented by the scaling down of our many nations to a global village. It simply makes sense that multinationals would rather do business than waste precious time and resources fighting about it in the courts of a foreign country under foreign laws. Yet, disputes inevitably arise, and companies are realizing that to stay competitive, the aforementioned advantages of the arbitration process may be their key to success in maintaining the bottom line. At the present time, over 108 countries subscribe to the New York Convention on the enforcement and recognition of foreign arbitral awards, which, as was mentioned by Mr. Haigh, is an international treaty established in 1959 whose purpose is to recognize and enforce both foreign arbitral awards and agreements to arbitrate. Despite the title, the purpose of the convention is to recognize and enforce both foreign arbitral awards and agreements to arbitrate. Indeed, the New York Convention is one of the most important legal developments in the history of international arbitration of commercial disputes. This presents multinational corporations with yet another reason to choose the arbitration forum to achieve international peace and justice in the coming era of international business. Perhaps the most significant benefit of alternative dispute resolution in the international arena is that it can be used not only to resolve a conflict, but to prevent one. Reference is often made to the importance of the legislation which has given legal validity and enforceability to the promise to arbitrate a future dispute when an arbitration clause is included in a contract. Frequently, the promise to arbitrate is an effective means of controlling controversy and discord. It has been shown that where this promise is applied in the commercial setting or in any segment of society, its effect is to reduce the amount of discord and dispute, even to the point where the formal process of arbitration may not even be necessary. It is a fact that less adversarial techniques such as mediation and conciliation often enable parties to resolve disputes in their earliest stages. On the cusp of the 21st century, our global village has also become a bustling global marketplace. Increased trade, encouraged by such accords as NAFTA and GATT, benefiting Canada, Mexico, and the United States, Latin America, and indeed the world, will, however, undoubtedly lead to international trade disputes. One example of a solution to these inevitable disputes, and one of which I am personally proud, was the recent formation of the Commercial Arbitration and Mediation Center for the Americas, created to resolve private cross-border commercial disputes relating to NAFTA. The leading national organizations, including the American Arbitration Association, the British Columbia International Commercial Arbitration Center, the Mexico City National Chamber of Commerce, and the Quebec National and International Commercial Arbitration Center, devoted to the advancement of understanding and responsible use of private dispute resolution, united and extended their already existing relationships to create a dispute resolution forum with identical arbitration and mediation rules, case administration procedures, and a multinational panel of expert neutrals established for that purpose. CAMCA, as it is called, operates as an impartial educational and administrative international forum devoted specifically to facilitating the resolution of private commercial disputes arising within the scope of NAFTA, and will study, promote, and administer procedures for the resolution of disputes through the use of arbitration, mediation, and other conflict resolution procedures. A 12-member CAMCA governing council composed of 4 representatives from each of the other 3 NAFTA countries, including the chief executive of each institution, is responsible for oversight of the rules, fees, and procedures for CAMCA. The multinational roster of neutral arbitrators, including 30 neutrals from each country and a cadre of neutrals from other nations, and education and training programs for arbitrators and mediators. The growing popularity of arbitration is reflected in the fact that Fortune 500 companies now include arbitration clauses in about 60% of all cross-border contracts, up from about 40% 5 years ago. As the field of international arbitration flourishes, with case filings at a statistical all-time high, dispute resolution professionals throughout the world must work together so that we may keep pace with its rapid development. We must look to our international allies, such as the International Chamber of Commerce's preeminent International Court of Arbitration. Located in Paris, the ICC International Court of Arbitration was founded in 1923 and has a long and impressive history as one of the most prestigious organizations of international conflict management. If the ICC's International Court of Arbitration constructed the architecture of international arbitration procedures, the London Court of International Arbitration certainly laid the groundwork. Inaugurated in 1892, this premier dispute resolution organization is overseen by the Corporation of the City of London, the London Chamber of Commerce and Industry, and the Chartered Institute of Arbitrators. A third major venue for the resolution of commercial transaction disputes is the China International Economic Trade Arbitration Commission. Established over 25 years ago, there is perhaps no better example of the parallel relationship of the necessity for an arbitral institution and the growth of caseload as a result of increased foreign trade. The American Arbitration Association, which consistently strives to be among those who set the standards for international arbitration, serves as the U.S. national section of the Inter-American Commercial Arbitration Commission. Francis Keller, one of the founders of the association 70 years ago, firmly believed that as the welfare of the United States is inseparable from that of other nations, the advancement of international peace and security through arbitration as a part of economic relations and through its use by international organizations or in contracts, conventions, treaties, and other instrumentalities or agreements is a major responsibility of Americans. With 37 offices in the United States and cooperative agreements with arbitration institutions in 51 other nations, the association's services are available worldwide. The American Arbitration Association often plays an instrumental role in developments relating to international arbitration law and practice. The association has participated as amicus curiae in important litigation affecting international commercial arbitration, participated in the development of the UNCITRAL model law for international commercial arbitration, and provides assistance and information to local groups seeking to establish or expand dispute resolution capabilities in their countries. In December 1976, the United Nations General Assembly adopted the arbitration rules of the UN Commission on International Trade Law, UNCITRAL. The UNCITRAL rules are intended to govern international ad hoc arbitrations, that is, arbitration with no institutions to administer the proceedings. Administration is left to the parties themselves, although an appointing authority is required to name an arbitrator or chairman if such an appointment proves necessary. If no agreement is reached on the appointing authority, then an appointing authority is designated by the Secretary General of the Permanent Court of Arbitration at The Hague. The UNCITRAL rules form a blend of common law and civil law rules of procedure. The UNCITRAL rules are widely acceptable to parties, particularly non-Western parties and nations, since the rules have been adopted by the United Nations. I am pleased to say that the American Arbitration Association, along with the ICC and the London Court of International Arbitration, are supportive of the UNCITRAL rules and often serve as administrator under the rules. International arbitrations commence, as do any other disputes, when one party to a contract containing an arbitration clause decides that it wants to seek relief through a formal process rather than through negotiation. Most international arbitrations are heard by a panel of 3 arbitrators, one appointed by each side, and the third appointed by the 2 arbitrators, or mutually selected by the parties. In selecting the arbitrators, thought should be given to their qualifications and experience. Since arbitration is a process of the parties, multinationals entering into cross-border agreements may desire to specify in the pre-dispute clause some of the particular qualifications of the neutral. Parties may, in the pre-dispute clause or during the selection process, specify particular expertise or experience, nationality of the neutrals, language in which the arbitration will be conducted, and many of the other procedural aspects of the process. The party initiating arbitration gives written notice of the arbitration to the administrative agency and to the party or parties against whom a claim is being made. Arbitral proceedings commence on the date on which the notice of arbitration is received by the administrative agency. The notice of arbitration often includes the following: a demand that the dispute be referred to arbitration, the names and addresses of the parties, a reference to the arbitration clause or agreement that is invoked, a reference to any contract out of or in relation to which the dispute arises, a description of the claim and an indication of the facts supporting it, the relief or remedy sought and the amount claimed, and may include proposals as to the number of arbitrators, the place of arbitration, and the language of the arbitration. What follows from the civil law approach is a kind of discovery of the other side's case, or at least that portion of the case that the other side sees fit to present. Apart from the pieces of information obtainable from the other side's written presentations and exhibits. Little discovery is legally mandated in international arbitration. An aspect of international arbitration that is often quite unfamiliar to lawyers new to the field is the preliminary framing of issues through, quote, terms of reference, close quote. As noted, the International Chamber of Commerce requires that the parties and the arbitrators enter into written terms of reference before proceeding with the presentation of evidence on the merits. The terms of reference are required to contain such information as the names and addresses of the parties and their representatives, the identities of the arbitrators, and more importantly, the contention and defense of the parties. Occasionally in international arbitration, there is an issue as to the law to be applied by the arbitrators. If the law is not specified in the arbitration agreement, and in the absence of a subsequent agreement by the parties, the arbitrators have to make a determination. If the issues before the arbitrators are limited to interpretation of the provisions of the contract and performance in accordance with those provisions, it often matters little what law is applicable, since, it is fair to say, interpretation of contracts to effectuate the intentions of the parties is a fundamental principle of the law of contract interpretation in the law of all nations. Courts in the United States